Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke and I want you to be a mock trial master. Let's talk about how you can make that happen. One of the most common phrases you'll hear during arguments related to hearsay objections in mock trial is effect on the listener. Effect on the listener is certainly a very effective, no pun intended, way to get around hearsay within the context of mock trial, but only if that phrase is used and employed correctly. I've seen it done very, very well a whole lot of times, and I've also seen it done really poorly a whole lot of times. When it's done well, it tends to win, and when you don't do it well, it tends to lose. So for those of you out there who may even just be asking, what does effect on the listener mean, and how can I apply that to my hearsay arguments? That's what we're going to dive into in this video. Specifically, I'm going to give you 3 things you need to know about that phrase, effect on the listener, to be able to use it correctly in your objection arguments, and hopefully in your next tournament, maybe even get around and win some hearsay objections. Sound good? Let's hop in. So the first thing you need to know about effect on the listener is that when you're talking about effect on the listener with an out-of-court statement, which by the way, out-of-court statement, again, that's what we object to hearsay on, you're talking about an out-of-court statement that is not being used for the truth of the matter asserted. Now, we're going to get into the weeds here for just a second, but bear with me. The definition of hearsay from Rule 801 tells us that hearsay statements are statements being used in court to prove the truth of the matter asserted. In other words, taking the thing that was said, whatever that statement is, and trying to prove in court that that statement was true. Now, I'm going to pause now. If you're confused at this point, don't worry. I've got another video on this channel explaining everything you need to know about the hearsay rule. Go watch that video first if you're a little thrown off right now. That's going to explain exactly what I'm talking about right here in very simple terms. But for the rest of this video, I'm going to assume you do understand what the truth of the matter asserted means. And when you're talking about effect on the listener, you're talking about statements that are not being used for the truth of the matter asserted. So if you look at a judge during an objection and you say, Your Honor, we're using this statement for the effect on the listener, the first thing you need to know about that is what you're really saying to the judge, and what the judge is going to hear, first of all, is this statement is not being used for the truth of the matter asserted. And that's the reason that statements being used for the effect on the listener purpose aren't hearsay. Because again, hearsay statements are statements being brought into court to prove the truth of the matter asserted. If you're not trying to prove the truth of the matter asserted, and the purpose of bringing in the statements is to show the effect on the listener, then it's not hearsay. All right, the second thing you need to know about effect on the listener is you need to simply understand what that phrase means. When you're saying that a statement, an out-of-court statement, is being used in court to show the effect on the listener, think about what you're saying. What you're saying is you're using that statement to show the jury the effect it had on the person listening to the statement. Effect on the listener isn't just some buzzword that means nothing. It means exactly what it says it means. If I were to say, Your Honor, we're using this statement not for a hearsay purpose, but to show the effect on the listener, what I'm saying is, instead of trying to prove the truth of this statement, what we're really concerned with is what happened after this statement. We're concerned with the effect that it had on the listener, on the person listening to it. We're not concerned with the verbatim truth of the words that were said. We're concerned with the fact that someone heard these words said and then did something. Right? Track with me here. So clearly those words had an effect on that person, on that listener. And it's that effect, the effect on the listener, that we want to talk about, that we're focused on here in court today. Let me give you an example. Let's say I've got a witness on the witness stand, and that witness is talking about a 911 call. I asked the witness, I said, why did the police respond? Why did the police arrive at this crime scene? And the witness says, someone called 911 and said there had been a death. Right? Is that statement hearsay? Well, you maybe could make an argument that it is, but I'm going to say that it's probably not. Because the question I asked the witness was, why did the police arrive on the scene? And by telling me someone called 911 and said there had been a killing, right, we're not really concerned in the moment with whether whoever this was who called 911 was telling the truth. Right? That would be the truth of the matter asserted. That would be a hearsay purpose. Based on the question that I asked, what we're really concerned with was the effect that that statement had on the listener. Right? In that moment, I'm concerned with, why were the police on the scene? Why did they come to the crime scene to begin with? And that statement made to 911 is the answer to that question. And so in that moment, we're concerned with the effect that this statement had on the listener. And in this case, that effect was the police showed up to the scene. The listener of that statement is the 911 dispatcher. That listener, probably dispatched the police. And that's the effect that that statement had on the listener. Again, in that moment, we're not concerned with whether there was actually a killing. We can probably get that evidence from somewhere else. But for the moment, we're using it for a non-hearsay purpose to show effect on the listener. That's what this phrase, that's what this hearsay exemption is all about. Before I get into the third thing you need to know about effect on the listener, I want to make sure you know that my book, Mock Trial Masterclass, is available for purchase on Amazon. Guys, I know that objections and the rules of evidence can be really overwhelming and complicated and can just seem confusing. So what I've done in this book is I've boiled it all down into easy to read and simple to understand explanations for what these rules mean, how to argue them, and how to make good objections in general. There's 2 chapters in this book all about this stuff. There's a chapter on the rules of evidence themselves, and there's a chapter on objections themselves, making them well, defending them well, arguing them well. And if you want all of that content and plenty more about how to succeed in mock trial as a lawyer and as a witness, you can pick up a copy by clicking the link in the description on YouTube or in the show notes on podcast platforms. All right, the third thing you need to know about effect on the listener is that if you're going to use effect on the listener in your argument, if you're going to tell the judge, Your Honor, this isn't a hearsay purpose, we're using this for effect on the listener, you need to tell the judge what that effect was. Right? When I talk about arguing objections, I say all the time that you need to, number one, return to the rule, right? You need to cite the rule that you're dealing with. And then number two, you need to connect that rule to the evidence in question. What we're talking about here, telling the judge what that effect is the connection part. Way too often I see attorneys in their hearsay arguments start off really, really well and then stop. It usually sounds something like this. So there's objection hearsay on the other side. Now it comes to me. I'm going to return to the rule. And I say, Your Honor, under Rule 801, hearsay is defined as an out-of-court statement being offered to prove the truth of the matter asserted. But we're showing this for effect on the listener. And then I stop talking. Now, I've even seen people win objections using that, and it's not good, but maybe it gets the job done. But how much better do you think it would be if instead of just stopping there, you said it this way? You said, Your Honor, under Rule 801, hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Well, this is actually, Your Honor, being offered for effect on the listener. And here's the effect that it had. Your Honor, in this situation, the effect on the listener being the 911 dispatcher, was that by hearing this information that there had been a killing, the 911 dispatcher dispatched the police, and that tells us how and why the police arrived at the scene. That's the effect it had on the listener, and the jury just needs to know this information for important context. Which argument for that objection was the better one? Right? It was obviously the second one where we explained for the judge what that effect that we're talking about is. And that's what you've got to do if you're going to talk about effect on the listener in your hearsay objection arguments and responses, is you've got to tell the judge what that effect is. Because if they weren't listening closely, or if you're kind of working deep on that effect and it's not clear right off the bat, you've got to make it painfully obvious for everyone what you're talking about. And if you can do that, if you can look at the judge and say, we're using this for effect on the listener, and here's what that effect was, and here's who the listener was, then the judge is going to be far more likely to agree with you and side with you and rule with you on the objection. I hope all of that makes sense. If you have any questions, please leave them in the comments. I'd be happy to answer any questions you have on this topic. Again, I know it can be complicated. I know it can be confusing. If you're still a little bit, maybe there's still some cobwebs up there, go back, watch the video again. I think maybe seeing it a second time will help some of these ideas solidify. But at the end of the day, just remember, effect on the listener, we're talking about a non-hearsay purpose. We're talking about an out-of-court statement not being used for the truth of the matter asserted. We're talking instead about the effect that that statement had on the person listening to it, aka effect on the listener. And when you're making these arguments, you need to tell the judge what that effect was and also who the listener was. When you do that, I know that your hearsay arguments are going to rise to the level of a mock trial master.